And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. My name is Vicki Henry, and I'll be your panel chief today. I'm delighted to be joined by Justices Lemire and Shin. We only have one case on this morning, so we'll have that case, and then we
I am frozen.
Okay, well, let's see. You're moving for us, so it just may be that my internet is not so good. Just let us know if it's unfrozen. Now she seems frozen for me.
Me also.
And we are back live.
Excellent.
I don't know what's going on, Your Honors, but I'm not hearing anything.
I just started talking. Can you hear me now? Attorney Anderson, are you able to hear?
And we are live.
Good morning. This is take two for the October 6th sitting of the appeals court. We're having one case this morning, and I am Vicki Henry. I'm your panel chief. I'm joined today by Justices Lemire and Shin. We will be on Zoom, but we will otherwise proceed as if we are in the courtroom, and you should assume you're being recorded at all times because this is being live streamed. Each side will have 15 minutes. We do not have rebuttal. If you have any technical issues, we will resolve them and we will finish the argument. The case this morning is 2019-P-0703, Commonwealth versus Daniel Nash. Ms. Scarpiccio, please proceed.
Good morning, Your Honors. My name is Rosemary Scarpiccio, and I represent Mr. Nash. I'd like to address two issues in my brief this morning, if I could, in the limited time that we have. The first is the erroneous playing of the 911 tape at trial, which violated Mr. Nash's rights under the 5th, 6th, and 14th Amendments to the United States Constitution, as well as Article 12 of the Massachusetts Declaration of Rights, because the call was testimonial, was not an excited utterance, and precluded Nash from confronting and cross-examine the hearsay and the first complaint evidence within the call. The second issue I'd like to address is the jury instruction error that the judge made, including an instruction where he suggested that the victim was unconscious, when in fact that was an issue that was a live dispute at trial as to whether or not the victim was unconscious or not. With respect to the first issue, Your Honors, the 911 tape. The issue here is that the Commonwealth sought to introduce this tape not for the truth of the matter asserted according to them, but they wanted to introduce it to impeach a witness as to what was happening in the background of the 911 tape. The problem with that is threefold. First is that
Counsel, I'm not aware that we have the 911 call or even a transcript of what was played to the jury.
You do not. So here is the problem. The trial court and the trial attorneys didn't mark it for identification, and it wasn't marked as part of any exhibit. In other words, it didn't go to the jury, it was played. So what we have in the record right now is some cross-examination based on what the parties believe they can hear in the back of the tape, and an instruction by the trial judge indicating that if they hear something on this tape, they can consider it, but it was not introduced as an exhibit. So I'm in a position now where I'm most likely going to have to move to expand the record to have this court review that tape, but it's an unusual circumstance because it's not marked for identification. I have a copy that I received from the trial attorney But I have no way of indicating if that's the actual tape that was played. It's the only one that I have. But I'd like to move to expand the record so that the court can understand.
But counsel, even if we have a copy of the tape or a transcript, it seems like from the exchange between the judge and the attorneys that only portions of the tape were played. So how do we know what the jury actually heard? Even if we have the tape, we wouldn't know which parts the jury heard.
I think that that's a huge problem in terms of why it wasn't marked for identification or why it wasn't clearly marked. I know
Right,
that the trial
how
attorney.
is that something we can resolve in this appeal? Even if we get a copy of the tape, we would still need to know which portions of it were played to the jury, right?
Yeah, my understanding is that the tape was played to the jury in its entirety. That's what I understand.
Well, you know, I'm looking at when it was played, and the judge says, can we get, you know, a snatch of the call that is no more than this is the mother's name, I need you to click, right? And then later there's an exchange where the judge says, how long are you going to play this for? And the ADA responds, probably a second or two. So it seems to me that the tape was being started and stopped. And, you know, even were the record to be expanded to include a copy of the tape, that doesn't answer the question of which portions were played to the jury.
You're correct. It doesn't answer the question of which portions were played to the jury. I can tell you, in having reviewed the tape, what's contained on the tape is multiple levels of hearsay. That's what the trial attorney was concerned about when they were doing the voir dire regarding the tape, because the tape itself suggests that the mother calls because the sisters are fighting and she needs some backup, according to what she's telling the police. And she indicates on the tape that one of her daughters has disclosed that she had been raped by ultimately who turns out to be Mr. Nash. It goes on to indicate that this daughter had disclosed to both the mother and the father that morning at 6 o'clock, and then disclosed a little bit later to the sister. So there appears to be at least 3 fresh complaint witnesses contained within that tape. And even though there's a portion of that tape that the judge says, how long are you going to play? The trial attorney was very clear that he was concerned about the fresh complaint evidence coming in. It was something that he argued about. It was something that the judge indicated that he would instruct the jury about regarding a limited instruction. He did, in fact, instruct the jury with a limited instruction and indicated that they were only to consider the tape insofar as it may have been used to impeach the witness. But this is one of those rare occasions where I think that it was such an abuse of discretion, because the limited instruction just clearly did not cure the error in this case. The error with respect to the 911 tape was significant to Mr. Nash.
So are we supposed to just assume that the additional complaints were played for the jury? Don't we need some additional information about an affidavit or something about which portions the jury actually heard? We can't assume that the judge let in multiple complaint evidence on this record.
I understand the court's position with respect to what the record is. Again, you know, it's unfortunate that the tape wasn't transcribed by the court reporter as it was coming in. It's unfortunate that it wasn't marked for identification. It's unfortunate that it didn't get redacted in the form in which the jury heard it. So that would have solved all these problems. None of that happened at trial. So we're stuck with the record as it appears right now, or on the alternative, the court can remand it back to the trial court for a hearing as to what exactly was introduced as far as the tape is concerned. Those would be the options I think that the court has. And I think because this was such an important issue for Mr. Nash at trial, that the court really needs to understand the depth and the breadth of the 911 tape to have a better understanding of why it affected Mr. Nash's trial in such a way in which it prejudiced him and prevented him from getting a fair trial. The tape itself, just so we're clear, the tape itself never came into evidence, but I can tell you that the playing of the tape for the jury, it's very, very light in the background in terms of whatever the alleged victim is saying. And it's unclear to me as I listen to the tape, whether or not she's upset because she's fighting with her sister, she's upset because she's just claimed that she was raped. It's very unclear as to what the source of her being upset is at that point, but you can definitely hear in the background her saying, comments like, why would I make this up? Why don't you believe me? Those types of comments that are what the judge allowed the jury to hear. And even if this court was only to consider those comments, the why would I make this up and why don't you believe me? Those comments themselves are hearsay without any exception, because you have to remember that.
Well, I hear what you're saying, that we could remand for a hearing, but procedurally, not just for this case, but for other cases, don't we want that to happen before you do your brief? I mean, was there a window when you should have moved to reconstruct the record here?
Well, looking back now in terms of what I know now, Judge, certainly if that's on me, if I did not move to reconstruct the record in the right way, that should not be held against Mr. Nash in any way. If that was my error, it's my error. And certainly Mr. Nash should not be faulted for that. But my position with respect to the 911 tape and the issue of what was played and what wasn't played as far as the jury is concerned, I think is an important enough issue so that this court can remand. Certainly, would you like for it to have happened in a different way? I'm sure that the court would have liked for it to happen in a different way. I would have liked the record to be protected better, but that didn't happen. So we're left with the record in which we have right now, Judge. And in terms of this issue, I would suggest that even if you consider what we know was played to the jury, which was those snippets of why don't you believe me and why would I make this up? I have trouble understanding the Commonwealth's position that somehow that could be used to impeach a witness who never made those statements. In other words, this is the sister on the stand at the time, and this is the mother who's making the 911 call, and this is the background information from that 911 call that is being used to impeach a witness on the stand about whether or not the sister was crying or not crying at the time that the call was made. And it's very unclear to me when you listen to the call whether or not she's crying about the fact that she's claiming she's just been raped, or she's crying because the mother is claiming that she's going to need some assistance because she says she's going to need backup because the girls seem to be fighting. And she makes it clear on the tape that she needs backup because there's an altercation going on between these two girls. So I'm not even sure in the first instance whether or not this tape purports to be what it's supposed to be in terms of impeachment. So it's certainly an attempt to impeach with extrinsic evidence, not generated by the witness who's on the stand, not something that is a prior inconsistent statement with respect to the witness. In this case, it's almost like using somebody else's police report to impeach a witness. You can certainly use that to refresh a witness's memory. In other words, what happened is there should have been a break. The tape should have been played to the witness. If the witness acknowledged that it refreshed her memory, then she could have been asked about it. That would have been a way to avoid the tape in its entirety and all of the hearsay and first complaint evidence contained within that tape. The fact that the victim is crying and or indicating that she's, somebody doesn't believe her, that plays on the jury's emotions to the point where it now looks like the Commonwealth is looking to generate more sympathy. In this case, indicating that her family doesn't believe her, that her, and that she would have no reason to make this up. The reason that I think that that's important is because the Commonwealth doesn't call the mother or the sister as a fresh complaint witness. Either of those two witnesses as a fresh complaint witness. Instead, they play this tape as sort of a Trojan horse to get the evidence of the fresh complaint before the jury, to get the idea that her family didn't believe her before the jury, and without any valid exception. This was testimonial for sure. There's no valid exception to why it should have been played under these circumstances. It's not an excited utterance because according to the way it came in, the rape happened the night before, according to the victim. And she indicated that she showed up at 6 o'clock in the morning and disclosed to her parents. And almost 45 minutes later, there was a call to the police after the other sister arrived, and there was some altercation in the house at that time. So it doesn't fit within any of the exceptions to any hearsay rule. And when you evaluate the probative value versus the prejudicial effect of that tape, I would suggest that this is one of those limited cases that I think we can look to Commonwealth versus Crawford, where the court found that even though there was a limited instruction in that case, it was an abuse of discretion to let in evidence of a prior bad act because the probative value did not outweigh the prejudicial effect. And that's what I'm suggesting happened here with that tape. And I'd like to move on.
Help us out and just let us know, how did the fiance, I'm going to call her, the sister, end up at the parents' house that morning? Did she just happen to be an early riser and go over, or did someone call her and
No,
tell her?
I believe that the mother called, the mother of the victim and her sister called the fiance, and she came over.
Okay.
So it was first disclosed to the mother and father, then the fiance came, then there was some altercation between the fiance and the alleged victim in this case, and then 911 gets called. But the first issue to 911 with the mother is her saying that she's going to need backup, and not backup because someone's been raped, but backup because there appears to be an altercation in the house between the two sisters. And so that's why the fundamental reason that the tape was introduced, I think, is not as clear as the Commonwealth wants it to be in terms of impeaching a witness with extrinsic evidence. And my suggestion is that in this case, it simply wasn't a situation where the tape ever should have come in under any circumstances. And if I could move on very quickly, because I know I'm running out of time, to the jury instruction issue. One of the instructions that the judge gave to the jury in this case is an instruction regarding whether or not there was evidence that the victim in this case was unconscious. What the trial judge said is, in this case, there's been evidence that the complainant had consumed drugs and alcohol and was unconscious at the time of the alleged rape. That was the whole point of the trial, is the defense was consent, and the judge told the jury in an instruction that there was evidence that the victim was unconscious. That completely undermined Mr. Nash's defense at trial, which was consent, and relieved the Commonwealth of the obligation to have to prove beyond a reasonable doubt, A, whether or not the victim was unable to consent because she was unconscious, and whether or not Mr. Nash knew it. In an instruction like that, whether in this particular case, where the entire defense was consent, and that in this case, the allegation was that the victim was feigning unconsciousness, and there was some evidence to suggest that that may have been true, because in this case, there was evidence that she had recalled things that happened in the room while she was supposed to have been unconscious. For a judge to make a statement like that to the jury in his instructions, essentially validating the Commonwealth's position that the victim had been unconscious, it is erroneous and deprived Mr. Nash of a constitutional right to a fair trial. And I would suggest that requires reversal of his conviction. And with that, I will rest on the remainder of my brief unless the court has any questions.
So you're talking about, I mean, on our record, it's the jury trial, day 6, December 3rd, 2018.
Yes, 6-16 is where that instruction happens, Judge.
And is it just the line on page 16?
Well, in the brief, we expand on what it is, but the issue is that the judge is telling the jury that there's evidence that the victim is unconscious, and is that the Commonwealth makes, but not that there's evidence that the victim was unconscious, because it suggests that some is the judge is siding with the Commonwealth of what the evidence shows, and that's really invading the fact-finding process of the jury. It was up to the jury to determine whether or not the victim was unconscious. It was up to the jury to determine whether or not they believed Mr. Nash's defense in this case. But to have a judge tell the jury at the end of a trial that the victim was unconscious undercuts your entire defense. That's what I say requires reversal of Mr. Nash's conviction. There are other jury instruction issues that are contained in my brief. This issue that I rely on, but issues, and that's why I wanted to bring it to the court's attention today.
Thank you. Well, we understand your argument. Ms. Anderson?
Good morning, Your Honors. Audrey Anderson for the Commonwealth. If it pleases the if it's okay with the court, first I'd like to address some issues in the defendant's reply brief. The defendant stated in a reply brief that at trial, the victim remembered almost every detail of the rape. The victim testified that she was waking up in the guest room with the defendant standing over her. He had a cell phone in his hand, moving it up and down as if scanning something. She was able to identify a still photograph of herself from video footage, but she testified that she had no memory of what happened during that time frame. The second thing is concerning the 911 call. The transcript of the victim's sister's testimony impeached her testimony. The sole object of the prosecutor in putting in the 911 call was to impeach this testimony.
Right, but Attorney Anderson, on the 911 call, we do have a preserved error. It's constitutional. There's a confrontation clause issue here. And Attorney Scapiccio has suggested that, so for example, normally you would refresh a recollection of a witness by showing them a document. The jury would not see that document and you would ask questions. And she's saying here, the victim, the 911 call should have been played for the witness outside the hearing of the jury. That would have solved all problems because she would have heard it. She could have then been questioned about it and the jury would have never heard it. So what do you say to that?
That the 911 call should have been played because purely it was for impeachment. The judge gave limited.
Why does impeachment trump the Sixth Amendment confrontation clause rights?
I'm not saying that it does. I guess I'm really not understanding the question too well, because I believe the 911 tape was put in for identification. This tape was not even going to be put in until the witness gave her testimony, and she basically gave untruthful testimony on the stand. Then the prosecutor decided to ask the judge to have the 911 tape played, and I believe it was put in for identification. But as far as your question, I'm not sure if I can answer that, Your Honor.
Well, she's saying under Crawford that there was a limiting instruction, and here there was a limiting instruction, and that still resulted in a reversal in Crawford, I think.
But the limiting instruction here, it was very strong. The judge said if there were substantive statements from the victim's mother, that the jury be instructed not to consider its contents. The jury was instructed they could consider only the content of the call as it pertained to the witness's credibility. That was the only reason that they could consider that call, and was only offered for that purpose. That's the only reason the prosecutor had the 911 tape played.
Right, so I think the defense's point is that that could have been accomplished without violating the confrontation clause rights of the defendants by playing that tape outside the hearing of the jury and then having the witness admit, as she seemingly did, that she was wrong about the events of that morning. So you still get your credibility victory and the defendant's Sixth Amendment rights are preserved.
Well, the prosecutor chose not to do that. I can't.
Well, but that's not how we do. That's not the prosecutor's choice. That's the issue.
Well, I guess I don't have an answer for that question, Your Honor. I really don't have the answer for that. Okay. The other thing was the trial judges.
Not to hop on this, but you keep saying the 911 was marked for identification.
I believe that it was.
I mean, I'm looking at the assembly of the record that lists the exhibits. The identification exhibits tend to be marked with a letter and not a number, and I don't see that as it's A through E. I don't see 911 as an
You can-
identification.
I can double check.
All right.
Okay. And as it concerns the argument concerning the judge's constructions concerning the consent and the defendant's unconsciousness, judges do not have to use particular words when instructing the jury. The judge's instructions as a whole correctly conveyed the relevant legal concepts, and that's all that was required. The instructions given by the judge concerning evidence of Ms. Jones's consumption of alcohol or drugs and unconscious at the time of the rape and indecent exposure were proper, as there was considerable evidence that Ms. Jones was unconscious, had consumed alcohol or drugs, and was unable to consent. This
Why
is,
is it- Counsel, why is it proper for the judge to comment on the presence of evidence of unconsciousness? Why is it proper for the judge to comment that there is evidence of unconsciousness? That's a factual question. What was the point of the judge commenting on that?
because it was in evidence, and
But
his,
that's not for the, if that's for the jury, I'm not seeing why it was proper for the judge to comment on the presence or absence of evidence one way or the other.
I don't know why he said that. Maybe because there was so much evidence. Maybe he saw the tape. Maybe he's, well, I know he saw the tape. And the words aren't prescribed that a judge has to use. So maybe he just said there was, or this could be my, frankly, this could be my wording. But I don't think that it was. But I know that the judge said that it was, that the jury could consider that there was evidence of drugs or alcohol and that she was unable to consent, and that the instructions comported with Commonwealth v. Blanche. But I'm looking at the unconsciousness. I'm not sure right now if that was my words. Because it's not in quotes. The judge's instructions, I think, were page 16 and 17 of volume.
What I'm not sure I follow what you're saying right now. Are you saying the judge did not use unconscious?
Well,
I mean,
I
he
have
used-
here the instructions
his-
given by the judge concerning the evidence of consumption of alcohol and drugs and unconsciousness at the time of the rape.
What the record says in the judge, this is the judge's instruction. It's on page 16, line 21.
Okay.
In this case, there has been evidence that the complainant had consumed drugs and/or alcohol and was unconscious at the time of the alleged rape. Is that what you were concerned about, whether the judge actually said that?
Yes, I didn't have it in quotes,
All right,
so
he
I
said the
wanted to
word
clarify.
unconscious. Okay, just so you understand.
Okay, just I wanted to clarify that. But I'm not sure why he did that, but it appeared from the reading that the instructions comported with Blanche. Basically, there was evidence the jury could see for themselves whether they thought that the that the victim was unconscious or not. And
So if I understand you correctly, you're saying that the judge was saying there was, well, I think you're saying the judge could have said that there was a dispute about whether the victim was unconscious at the time, and therefore we consider what follows after that. Is that right?
he could have said that, but I don't think he said that.
Right. I think that's the defense counsel's point, is that he put his thumb on the scale by not referencing the dispute, or that there was also evidence that she was not unconscious.
But the jury had all of that information before them. And he also told them that they are the ultimate trier of the facts, that the evidence, that they get to decide from the evidence. So it could have just been a misstatement. But that's what it was. That was his statement.
Well,
And there's nothing.
wasn't there a video that depicted her as being in the state of not being awake or unconscious?
Yes, I sent the court the video.
So the judge was commenting that there was evidence of her being unconscious. He wasn't saying she was.
No, I thought I made that clear that he thought there was evidence of her being unconscious. Yes, I sent the court the video of that. I sent the court video of the testimony. I'm sorry, the interview of the defendant and of the video of the sexual assault. Are there any further questions, Your Honors?
I have nothing.
Okay, the Commonwealth rests on its brief. Thank you, Your Honors.
Thank you.